Hi, everyone. My name is Alfred Steiner. I'm an artist and lawyer. Never sure which one goes first exactly in terms of my career arc, but here we'll be talking mostly about law. I've been practicing law for 25 years in the technology and media spaces with an emphasis on copyright and trademark, drafting and negotiating agreements. And because of my position as a sort of a technology lawyer with a lot of connections to the art world, and the legal world, I got into NFTs right after the Beeple sale, and because of many of my friends were asking me questions about them, and so I really sort of dove in. And for the last couple of years, that's been the majority of my legal work. Sorry, I see wasn't on the mic exactly. So I'm just going to talk to you today about licensing and rights transfers in the NFT space. It's something that's raised a lot of interesting issues for lawyers and caused a lot of problems for NFT projects. And so hopefully, if you're interested, you'll come away with a little bit better understanding of what the options are and what you might do. So you have a number of options for if you're launching an NFT project in terms of what you want to do with the rights to the associated work. So one of the options is to say nothing. That's what CryptoPunks did. And until Yuga, and there's a lot of misinformation about this in the space, but until Yuga launched the CryptoPunks NFT license, there was no license. So what rights you had to your CryptoPunk to use the image were very much in question. Maybe you had an implied license to display it for certain purposes, but if a museum was going to display it, that was going to be a problem because they would say, we don't see where you're getting the license to display it publicly, and we're not going to take that risk. So, but generally speaking, it is a good approach because it's flexible. You can always grant the users more rights. And obviously CryptoPunks is a very successful project, so it worked for them. If you don't say anything, you're not going to trip over something, which we'll see other projects doing later on in the presentation. So the other option, the other sort of bifurcation here is say something. And there are a lot of different ways to do this. You can, the two biggest ways would be either to grant a commercial license or a non-commercial license. Early on, the trend was to grant a non-commercial license that allowed users to display it on marketplaces and metaverse spaces and in other places like that. Murakami, or this is an artifact. If you have an artifact, CloneX with Murakami traits, this is the license, and you get a non-commercial license. It's pretty restrictive, but it leaves most of the rights with the NFT project. Again, though, if you were to launch with a non-commercial license, you can always tell your users, hey, by the way, we're going to give you more rights now. We're transferring more rights to you or your NFT owners. And so on the flip side of the non-commercial license would, of course, be the commercial license. And there were a number of these very early on, like the NFT license, which governed CryptoKitties and allowed users or NFT owners to commercialize the digital asset associated with their NFT up to a certain point. I think it was $100,000, something like that. And then after that point, if you wanted to go further than that, you would have to contact Dapper Labs and negotiate some sort of a deal with them. I don't think, as far as I know, no CryptoCat owner ever got to that threshold, but I'd be happy to learn otherwise. So the other thing you can do, and some projects have done this, is transfer all rights to the digital asset to the NFT owner. And this is my project, and I use it as an example because I've done a lot of things that I recommend that clients do with it, but I don't know, in some cases, no one else has done it, as far as I know. But for my project, it's called Your Story. It's an on-chain generative text. There's actually a rights grant that you can put it in the metadata. If you put it in the description part of the metadata, the rights grant, it'll show up on OpenSea in the description. So that's one place you can put it. I'll get into where to put it a little further on in the presentation. But so now that you sort of have the field, say nothing, non-commercial license, commercial license, or give all rights to the NFT owner. it's instructive to look at what not to do. So one thing, and this is another important point, one thing that that Yuga Labs did with respect to the Bored Ape Yacht Club collection is they said when you buy a Bored Ape, you own the art completely. So if you were buying a painting, that would make a lot of sense. You own that physical object, but you don't own any, you might not get any rights to reproduce it, you know, to put it on mugs or t-shirts, right? It makes a lot less sense in the digital space when there is no differentiation between the artwork and there is no physical object apart from maybe like bits, you know, on a server somewhere, which no one is arguing that's what you own, although I think the argument could be made. So what Yuga Labs did, despite saying that you own the art completely, they go on to grant a commercial and a personal and a commercial license. It's very broad. It lets you make derivative works. So for example, if I had a Bored Ape that featured the BAYC with a skull logo on the hat, I could make a derivative work that just consists of that slice and I could put it on t-shirts and put it on other things. So it creates significant trademark problems for Yuga Labs, potentially. So this raises this particular license grant, which was not very good, and they stole it from Hashmasks. If you just do a compare versus Hashmasks, the ownership provision, it's virtually identical. There are like 2 or 3 word changes from their Hashmasks ownership section. They deleted the word exclusive and changed Hashmasks to Yuga Labs. But the other 2 lessons from the Bored Ape launch is distinguish between the NFT and the digital asset. And if you're in this space at all, you may know that A16Z released a bunch of licenses called the Don't Be Evil licenses, and they do a very good job with that by saying, look, the NFT is personal property, you own that, and then okay, I can go on. I guess I better move on to other stuff because I don't have much time left. So distinguish between the NFT and the art. Those are 2 different things. And then also, the A16Z licenses do this as well. Unless you're going to grant trademark rights, which is very dangerous because it can result in a loss of rights due to naked licensing, say you don't get any trademark rights if you're going to be giving a very broad license grant. Okay, Moonbirds, something else that Moonbirds did, they said users will get full commercial rights, more before launch. Never said anything more before launch. 3 months after launch, Kevin Rose said, you know what, everything's going into the public domain. So if, you know, to the ape holder that I spoke with recently who licenses ape for $100,000 and had some Moonbirds, that might have come as a shock. Like, I can't actually license my Moonbird for hundreds of thousands of dollars because now anybody can use it. So where to put the terms? Put the terms on your minting website. Put the terms in the NFT metadata, in the description. I think I mentioned that before. Put the terms in the smart contract. The only other project I know that has done this is Terraforms by Math Castles, which is an amazing project. Or put the terms in the NFT itself. And I think this is my project, Your Story, is the only one that's ever done this. The NFT, the terms are in the token URI. The token URI is base 64, and when you translate that, it pops out metadata that contains the license terms. So with that, I think that's my last slide. Yep. Thank you, everyone.
Awesome.